All right. Good afternoon, everyone. For the record, Delegate Jazz Lewis. We're here for the Public Safety and Administration Subcommittee of Appropriations. We have 4 agencies before us today. Thank you all for making time on this Monday afternoon. We are going to start with the Uninsured Employers Fund. So we'll begin with analysis from Department of Legislative Services. Micah Richardson, you can begin, and afterwards we'll bring Ms. Burns. You can begin after the analysis. Micah, you start when you're ready.
Good afternoon. My name is Micah Richards, and I want to thank the Chair, Committee, and the great state of Maryland for allowing me to speak before you today. I'm presenting the Uninsured Employers Fund, referred to as UEF Fiscal 26 Budget Analysis. Starting on page 1, UEF protects workers whose employers are not insured under the Maryland Workers' Compensation Law. The Fiscal 26 allowance increases by 1.7% to $6.1 million. Page 2, Exhibit 1 shows 58% of the Fiscal 26 allowance supports medical service support provided by UEF. Page 3, Exhibit 2 shows the largest spending increase of around $124,000 is for salaries due to fiscal 25 cost of living adjustments. Page 4, as of December 2024, 2 positions have been vacant for more than 12 months. Page 5, Exhibit 3 shows the cost per resolved claim is on an upward trend, increasing by 160%. From fiscal 21 to 24 due to UEF's third-party administrator, referred to as TPA contract, and Corvell is the TPA. Page 6, Exhibit 4 shows the benefit payments increased by 31% in fiscal 24 compared to fiscal 23, which is the highest level since fiscal 20. Page 7, Exhibit 5 shows the expenditures exceeded the revenues in fiscal 23 and 24. Page 8, Exhibit 6 shows, starting in fiscal 22, the significant increase in administrative costs, which are payments to Corvell, is the primary cause of expenditures exceeding revenues. In the last 5 years, UEF paid Corvell a total of around $11.5 million. Corvell has secured $25 million in payments to UEF. The Board of Public Works approved on October 30th, 2024, for Corvell to remain as the TPA through October 31st, 2029. During this term, Corvell will receive $8.4 million. UEF expects for Corvell costs to decrease by 20%. UEF should comment on the need to retain Corvell and why the TPA's costs are expected to decrease. Page 9, the 2024 Joint Chairman's Report, referred to as JCR, requested for UEF and the Workers' Compensation Commission, referred to as WCC, to establish a work group to determine solutions for the long-term solvency of UEF. UEF and WCC's reports included multiple recommendations. First recommendation, have an overseer monitor UEF's administrative affairs. UEF should comment on the suggestion to utilize an overseer. Second recommendation, transfer claims management in-house. UEF wants an independent feasibility study to be conducted. Third recommendation, retain a private commission-based collections agency to pursue debts owed to UEF. UEF supports but prefers to also have the Central Collections Unit continue to collect debt. Fourth recommendation, UEF should seek to reduce fines, penalties, and assessments to judgments and bring civil collection actions. UEF supports. Fifth recommendation, increase the allowable assessment percentage on awards and settlements. UEF requested for Senate Bill 219, and the original bill proposed a 1 percentage point increase to the assessment. However, the new proposal is 0.5 percentage point increase from 2% to 2.5%. Sixth recommendation, make reserve setting mandatory. UEF opposes. Seventh recommendation, repeal the suspension of assessments once UEF's fund balance reaches $5 million. UEF supports. Eighth recommendation, redirect civil penalties from workplace fraud from the general fund to UEF. UEF supports. Ninth recommendation, transfer $10 million from the subsequent injury fund to UEF and readjust the assessment ratios. UEF supports. 10th recommendation, shift costs of UEF employee salaries and benefits to the general fund. UEF supports. UEF should comment on the options considered in the two reports. Page 10. In addition to Senate Bill 219, UEF requested for Senate Bill 227 to be introduced to require WCC to make the fund a party to a claim filed against an uninsured employer. UEF should comment on the impact Senate Bill 227 will have on the fund. Page 11, DLS recommends for UEF to report on whether a TPA is needed for the entire current 5-year contract. This report should be submitted by December 1st, 2025. Page 12, the Office of Legislative Audits, referred to as OLA, will submit UEF's audit report during calendar 2025. Page 13, there were 2 JCR reports requested in the 2024 session. Work group report on UEF's long-term solvency was presented earlier in this presentation and is shown in key observation 2, pages 6 through 10 of this analysis. OLA still has several steps to perform before they submit their report on the status of corrective actions related to the audit. And I updated the Senate's Finance Committee and Public Safety Subcommittee that UEF will become insolvent in fiscal 27 instead of the original projected date of fiscal 2030. The breakdown is in fiscal 23 and 24, the expenditures exceeded the revenues by around $2 million. As of January 2025, the fund balance is around $6 million, which is an increase compared to the closing fund balance of around $5 million in fiscal 24. This is because in the first 6 months of fiscal 25, the revenues exceeded the expenditures, and it is projected the expenditures will exceed the revenues in the last 6 months of fiscal 25. At the close of fiscal 25, 26, and 27, the expenditures are projected to exceed the revenues. The expected closing fund balance of fiscal 26 is around $428,000. In the first 6 months of fiscal 27, the revenues are expected to exceed the expenditures. Therefore, UEF can possibly fulfill expenses through January 2027. The expected expenditures will exceed revenues in the last 6 months and UEF will not be able to fulfill expenses by the close of fiscal 27. This concludes my presentation, and I'm available for any questions.
Thank you, Mr. Richards. Colleagues, any questions for DLS? Seeing none, Mr. Burns, you can approach and begin when you're ready.
Mr. Chairman, members of the committee, good afternoon. My name is Michael Burns. I am the director of the Maryland Uninsured Employers Fund. First, I would like to thank Mr. Richards for his excellent analysis, his thorough analysis. He has been a pleasure to work with, both professionally and personally. An outstanding analysis and person. And I just wanted to make sure that went on the record because over 9 years, I have not been able to say that about everyone I've dealt with. So I'm very grateful that Mr. Richards was here to do this analysis. As he noted, the Uninsured Employers Fund takes care of injured workers.
Mr. Burns, we have to pause for 1 second.
Sure.
Thank you all for that. We are back live. Sorry for the interruption. You were saying some very nice things of Mr. Richards. You can proceed again.
Thank you. Employers break the law and don't have workers' compensation insurance. Some misconceptions to clear up. This is not an insurance company. We do not issue policies. We don't write policies. We don't set reserves based on what our potential liability is because of policies. We do, however, set reserves, which we have done for about 5 years. We could not do that when I started 8 years ago because the agency was in such disarray it didn't even know how many claims it had, let alone how much their liability might be for those claims. But we've been doing it as a matter of course, and of course we will be happy to keep doing what we're doing already, and if that's an issue, as was brought up by Mr. Richards, we do it now. I could give you that information anytime you'd like. We are funded mostly 80 to 90% by an assessment, a 2%, up to a 2% assessment on most orders of the Workers' Compensation Commission. We do not control the amount of payments we make to injured workers. We pay payments to injured workers. We pay whatever comes in the door. That is what we do. As to the assessment, whatever the amounts are issued by the various commissioners and various orders, that's what we get from year to year. I will note for you, because the issue of solvency has been raised by Mr. Richards, that in the last 2 fiscal years, the amount of the assessment has been noticeably lower than it's been for my tenure there, starting in 2016, by the tune of about $2.4 million. The fund balance went down approximately $2.4 million. This agency has an issue with revenue, not expenditures. It is a revenue issue. Now, as Mr. Richards points out in your analysis on page 2, last year the legislature raised the penalty for failure to have insurance from $10,000 to a maximum of $25,000, which this agency and the administration sponsored. This penalty is now beginning to be enforced by the Workers' Compensation Commission. I had estimated, and it was an estimate obviously, for the first year that the agency would receive approximately $500,000 more because of this penalty. However, that's not going to be the case for various reasons. However, when this penalty is enforced and the numbers start to come in, this will help alleviate the situation Mr. Richards has very clearly and accurately presented to you about the financial health of the agency. Secondly, and I'm jumping ahead because we're talking about the financial health of the agency now, House Bill 193, which is matched by Senate Bill 219, are administration bills to raise the optional assessment ability of the board from 2% to 3%. Now, there's been a lot of discussions between legislators and interested parties and the administration, and it has been agreed that that bill will be amended to a 0.5% increase in the assessment when optional. Let me explain to you how that works, too, because, again, people just don't seem to get this. There is a 1% assessment that the Uninsured Employers Fund gets every year as a matter of law. In the statute, it states that should the board determine that in order to maintain the financial stability of the fund, that can be raised to a maximum of 2%. And that's where we are now. It is not a 2% assessment. It's a 1 plus 1. Very important to remember that. What the bill will do, House Bill 193, will make it an optional increase to 2.5%, which should generate between $1 and $3 million a year for the fund. I know what you're all used to dealing with. These numbers are like minuscule, but they are very big numbers to the Uninsured Employers Fund. So if that 0.5% is enacted, and it certainly seems that both the Senate and the House committees are in favor of the 0.5%. That will be an additional $1 to $3 million into the fund. Now, where are we going to be in fiscal '27 based on that? No one can predict, because I can't predict to you what the orders from the Workers' Compensation Commission will be, how much they'll be, how much comes in. But certainly by next year, we'll know what's going on with that. Certainly. So although it sounds like the train is close, the train is not barreling down on this body or this fund yet. Going down, I'm sorry, I'm like the machine that just didn't work. I'm doing my best with technology here. Page 5, cost per claim continues to increase. Yeah, it does. We pay medical claims. Here's a surprise. We're paying more for medical claims. Who isn't? We pay because that's what happens. I will note a couple of things for you to give you an idea of how this actually works in the real world, though. We have a claim right now to pay for $454,000 out of our $6 million fund, which is a lot of money. But that's what the hospital bill is for the injured worker whose employer didn't have insurance. Are we going after that employer, you ask? Of course we're going after that employer. Obviously we're going after that employer. The fly in the buttermilk, as the cliche goes, with that is, though, a couple of things. One, employers will sometimes, some of these people are really sleazy, okay? What they will do is rename their company from Michael Burns Enterprises to Mike Burns Enterprises. They'll file a new company, and they will attempt to dodge legal responsibility. However, they are personally liable, so we do get them. And so what happens then, under federal bankruptcy laws, they declare bankruptcy because of the way federal bankruptcy law is set up. Our debt goes away. That's how it works in the real world, all right? That is how this works. What we do, what I do, and I am happy to do it, I do it all the time, I am always open for business. I'm always open to negotiate with people because some money's better than no money. And a payment plan is better than a bankruptcy. We do that all the time. I will tell you, I have at least one payment plan that's going for 40 years because the alternative is to get no money. So that is what we do. We also, however, when we get a payment plan, get a confessed judgment note. And if any of you are attorneys, you know exactly what that means. And perhaps just in your travels through the General Assembly, you know what that means. A confessed judgment note means that if they stop paying, they've agreed they're legally liable, we can go and get immediate enforcement of the whole debt. So we have developed over the past 8 years a very elaborate system of ensuring that we immediately go after debt and we are aggressive about going after debt. I can also tell you, though, having spent years attending conventions, meetings of other uninsured employers fund representatives around the country, that every state has the issues we have. Some of the states are much more aggressive than Maryland. In Florida, they have a 70-person enforcement mechanism available. And when they go to collect the debt, they circle buildings. They block entrances, they go to the office, they slap subpoenas and warrants on those people, and they're out of business. We, obviously, that is probably the gold standard in the country. We don't have those tools. In order to have those sort of tools, I would have to have a much more enlarged staff, and we are 100% self-funded. Not only do we basically raise our own money, we are self-funded. We get no money from the general fund. So I have to run, and we have to run that agency like a business. I cannot spend money I don't have. I can't hire people I can't pay because the money is not there. The goal, the focus is always on the injured worker and their family. That has to come first. That must be our first issue and what we're always looking at. So are the claim costs going up? Yes, they are, and they will continue to go up. If you go down further, we will get to page 6, report on long-term solvency of the fund. I am sorry there is not one report to you all. What the JCR requested was a report, one report, from a work group to the legislature with recommendations. That is not what you have received. And I as a former legislator and an agency head who's responsive to you, I apologize for that. Some members of the work group did not wish to do it that way. That was their decision. We did not have as a work group really what you would have expected, which were recommendations everyone discussed and agreed to. You've got 2 separate reports, and I think you have to understand one of those reports is from the Uninsured Employers Fund. One is from the Workers' Compensation Commission. So that, what you have is the opinion of the UEF and the opinion of the Workers' Comp Commission and various members of the work group who may or may not agree with all those findings and decisions. So if you wish, I can go through, and if there are questions about this, I'll be happy to. All these findings and recommendations about what we came up with. Some of these are really good ideas that are easy to do. Some of these are really bad ideas we don't think you should do. We've been very clear about that. I guess the most important is something that there was no consensus and at all about in the work group is this idea of having this state agency have some kind of an outside person come in and run it and monitor it. I would like to say a couple of things about that. First, having been a former judge, I've looked through the code about this agency. And not surprisingly, the code, which you have set up in 1983, establishes a board for the agency, which by law is in charge of the agency. The board hires a director who is responsive to the board. That's me. The director, by law, is mandated to run and manage the agency. That's what the law says. That's what I do. I run and manage the agency, including hiring people, staffing. That is the director's decision. That's the way the law is set up. That's the way the board's set up. There is this proposal to have some outside person come in and monitor, be a monitor czar over the board. And the board and the director are supposed to report to them. I'm not quite sure, and I assume it would be whatever you all would say in the enabling action that would establish this. I'm not quite sure what I'm supposed to do if some monitor says one thing and my board says something else. What am I supposed to do? And one of the specific proposals is staffing. You're going to have an outside person determine state staffing in a state agency. Well, suppose I, who has the specific authority in the code not to go along with that, don't go along with that. What happens then? You know, lady and gentlemen, I'm always looking at what's going on in our government because I'm a nerd about government and politics, and I think it's important to know. And I saw this, that the Board of Public Works approved a contract for $445 million on technology, which is great. And I think it's investing in technology is a smart thing to do. But then I read that you all are trying to find out what happened to $1.03 billion of our money that apparently somebody won't answer to you. And I said to myself, well, shouldn't they have a monitor? I mean, whoever does that, shouldn't they be monitored? What's going on?
Are you starting to come to a close?
Yes, I am. This agency, for those reasons, strongly opposes this idea of a monitor. The proposed legislation's easy. Senate Bill 227 is dealing with how we pay. What that bill will do is clean up a mess of a statute and enable workers to get paid quicker and easier than they get now. that get paid now, and that's what that bill does. The other bill, Senate Bill 219, House Bill 193, is, as I've discussed, the increase in the assessment. The compromise on that is 0.5%. I strongly request you give the agency that option. And that, Mr. Chairman, is my testimony for today. It's delightful to be here. I used to work across the hall, and I'm open to any questions.
Okay. Colleagues, any questions? Delegate McComas.
Thank you, Mr. Chair. I just have a quick question. Do you feel the folks that don't get workers' compensation insurance, the employers, that they're dealing with folks that are maybe immigrants that maybe don't speak the language, that don't understand insurance and can get taken advantage of, so that, I mean, I'm just kind of curious if that's the kind of folks, and that they do dangerous jobs like putting on roofs, cutting trees, you know, things that can really rack up some serious injuries if they're hurt.
You must have been hanging around our agency, delegate, because you are absolutely correct.
Oh, okay. Well, I wasn't
There, and this is odious, what goes on. And the Attorney General, I was in a bunch of hearings last week. The Attorney General has a bill about workplace fraud, which we deal with all the time, but we're, for some reason, I've tried to get us involved in that, and we just haven't been able to get labor to get us involved. But what happens is, and I think it's hard to tell because, you know, we don't keep track of this because it's not part of what we do, and we don't care about people's immigration status. We take care of injured people, okay? Not American citizens, not non-citizens. We take care of injured people. But the way this scam works is many unscrupulous employers in construction, in landscaping, hire these poor people who aren't from this country, don't speak our language, have no idea what's going on. Give them cash, something happens, they're out of luck. We do a lot of that. I'd estimate about 30% of our claimants currently are undocumented folks. So yes, that happens a lot. You cannot, in my mind, honestly, be too hard on these types of people, and the fine increases, I would like to think, just the beginning of a more vigorous enforcement mechanism against the bad people.
Colleagues, any further questions? So I will start, and with full respect as a judge and a former legislator, I would encourage you, when you testify before us, in your tone and candor, do not dictate to this body on how we should approach governing. It is not received well. I just want to say that up.
I certainly didn't intend that at all, Chairman Lewis. I'm sorry if it came across that. I'm very passionate about this agency.
That comes
No,
across.
I do. I apologize to you. I apologize to each of you. I would never do that consciously.
Just so you know, as far as comparison with the recommendation of which this body, none of us were on that work group, but you know, the biggest thing, at least I can say, that for the House, the majority party, at least for the House, in defending the blueprint for Maryland's future, in there, we have structures in place for our duly elected school boards across the state. If they do not make good use with state funds, we will have accountability boards of sorts come through to make sure that in the public's taxpayer dollars are spent appropriately. That's an outsider coming in. Now, I think we do have concerns about the longevity. You do not have control over those revenues. I think the bills are promising that will help with that. But we do have some questions that relates to the cost per claims going up. We would like you to speak to some of those other recommendations. One question I have specifically, because we have been giving support to the comptroller's office on leveraging AI so they can identify people who are evading taxes. I just want to know, in addition to responding to the question on the jump of cost per claim between 2021 and 2024, are you all engaging in leveraging technology to help identify some of these problematic actors earlier so that we can give you the appropriate support that you need?
Yes, sir.
So
very
start
much.
With the cost per claim.
Very much so. One of the benefits of the outside national professional third-party claim administration, TPA model, is you get a system of technology for claim monitoring with that. And that's part of what we get for our amount of administration costs. And in this case, by this company, it is called CareMC. And it is, by my research, perhaps the most advanced, best claims monitoring system offered by a TPA in the country. I can tell you that there are apparently vendors who do not buy the actual physical services of that company. They just buy the use of the claim system and the technical support for that. And one of the reasons back in 2019 when we had an emergency procurement because what was going on at the agency didn't work and was not legal and collapsing was that system. I could tell that system was remarkable. It's their bread and butter. So they are constantly updating it. We have a vendor, because we're a small agency, we utilize Do It, obviously, but we have a vendor who was there when I arrived and is currently there. And in fact, we're in the process, even as we speak, of updating the computer systems at the office to make them current, I guess, even as we're talking about it. And obviously, I didn't get a chance to mention to you, and I should have, and I apologize for this, that we're also obviously monitored by your Office of Legislative Audits, and we're finishing that 4-year audit up right now. And as you all know, that's a financial audit, but it's also a technical audit. And actually, we are working with your Office of Legislative Audits technical people on the issue I just mentioned. So we are always trying anything we can do to make, to move away from paper and stuff, books, to computers. And yes, we are.
Can you speak a little bit more to the Central Collections Unit piece?
Oh, yeah. By law, after 90 days, all your state agencies are supposed to, and I imagine other people have MOUs like we do, but all your state agencies give their debt to the Central Collection Unit. When that happens legally, they have the authority legally to collect that debt, and that transfers from the agency to the CCU. Before I got to the agency, we had worked out an agreement where we had 180 days as opposed to 90 days to transfer that debt. But when I arrived, the issue we had, and this issue has been resolved, but the underlying issue has not been. The issue we had is after 180 days, the debt went to the CCU and we couldn't collect it anymore, which would have been fine, except the Central Collection Unit is incapable of collecting our debt. And you could hold a hearing about that for an afternoon. Obviously, we have tried repeatedly to assist the CCU, to encourage the CCU to do whatever we could to assist them to collect our debt. When I arrived at the Uninsured Employers Fund, there was about $58 million at the CCU. They average about $5,000 a month. That's what they collect. In 2021, we worked out a member of understanding with the CCU to both have joint jurisdiction over the debt. So we could keep legally. So they could collect and we could collect, except as you just heard, they aren't really able to collect. But my attitude about that, as I think I made clear in there, and the agency's attitude is, the more entities collecting, the better, which is why the recommendation about getting a collection agency, we are busily working on that as well. Because I would estimate there's somewhere around $70 million sitting at the CCU now of this agency's debt, and they can't collect it.
So with that, you are then in support of a pay-for-performance type model to get more of this in expeditiously?
Oh, absolutely.
Okay.
Absolutely.
Want to be clear there. All right. Here's what I would suggest. I would like to have an offline follow-up with you for everyone's time's sake, because we are all very concerned about the long-term solvency.
Absolutely.
And making sure that January of 2027, we're not worried about people's inability to get support for the harm and whatnot that they're facing. But I, just for time's sake, I would love for us to follow up offline. So.
Honestly, Mr. Chairman, I love coming down here. Anything I can do with any of you to make this work better, I'm there.
Thank you so much.
Sure.
All right, colleagues, any further questions for him? All right, thank you so much.
Thank you so much. I really appreciate your time. And again, Chairman and members, I apologize if I was a little too zealous. I really do.
All right, now we're going to move over to Department of Corrections, Administration Offices. We're going to begin with an analysis from Ms. Barber, and then Secretary will bring you up.
Good afternoon. Thank you, Mr. Chair. My name is Catherine Barber, and today I'll be presenting the fiscal 26 budget analysis for the Department of Public Safety and Correctional Services, Administration, and Offices. The allowance totals $232.8 million, which is an increase of $18.7 million, or about 9% from the working appropriation. The performance analysis begins on page 5. Starting off with recidivism, as you can see in Exhibit 1 on page 6, the one-year recidivism rate decreased across every release category among the fiscal 23 release cohort. 197 individuals were returned for a new offense within 1 year of release, which is a 20% decline from the fiscal 22 release cohort. DPSCS was asked in the 2024 Joint Chairman's Report to submit a report discussing 3-year recidivism data, its analysis of recidivism trends, and a comparison to past years and other states. However, at the time of writing this analysis, DPSCS has not yet submitted this report. The data included in the report has historically been more comprehensive than the Managing for Results performance measures, so without it, DLS's ability to discuss recidivism trends is limited. DLS recommends restricting $100,000 pending a report with 3-year recidivism data for the fiscal 2016 through 2022 release cohorts and the impacts of incarceration on the future outcomes of returning offenders. The next performance measure is contraband levels. As shown in Exhibit 2 on page 8, overall contraband find occurrences across all search methods increased by 39% from fiscal 23 to 24. In fiscal 24, weapons were the most frequently uncovered contraband at 44% of all fines. This is an extremely unusual increase of 375% from fiscal 23 and poses a grave and immediate threat to the safety of inmates and staff. DPSCS should comment on the reason for this increase and the steps being taken to reduce weapons contraband in its facilities. Until fiscal 24, controlled dangerous substances, or CDS, had been the most common type of contraband found. CDS comprised 34% of all find occurrences in fiscal 24, and the CDS find rate increased by 56%. DPSCS reported decreases in the find rates for tobacco, tools and escape paraphernalia, cell phones and their accessories, and alcohol. Exhibit 3 on page 9 shows that the overall contraband level detected by the K-9 unit in fiscal 24 has dropped to a level last seen before fiscal 2020 due to a rise in undetectable CDS in pretrial and correctional facilities. According to DPSCS, this new form of contraband includes synthetic cannabis and mail sprayed with insecticide, neither of which can currently be detected by the K-9 unit. The next measure is the Central Home Detention Unit population. As you can see in Exhibit 4 on page 10, the average daily CHDU population has remained relatively consistent since the pandemic, increasing only slightly in calendar 24 to 208 individuals confined to their homes. Finally, in the 2024 JCR, the Budget Committees requested that DPSCS include a more detailed breakdown of correctional program participation in its annual MFR submission. The requested measures were not included in the fiscal 26 MFR, so DLS is recommending adopting committee narrative requesting the inclusion of program participation data in future MFR submissions. Moving on to the budget, there are 3 proposed deficiency appropriations totaling $2.6 million to support software maintenance, address fiscal '24 operating shortfalls, and fund inmate healthcare costs, mostly for individuals in CHDU. DPSCS administration and offices receives a total allowance of $232.8 million. The Information Technology and Communications Division, or ITCD, receives the most funds of any division at $59.6 million, or 26% of the total budget, followed by Administrative Services at 23%. Exhibit 5 on page 12 shows agency spending by program. The $18.7 million increase from the working appropriation is broken out in Exhibit 6 on pages 13 and 14. General funds increased by $19.4 million, approximately $18.2 million of which is for personnel costs related to transferred positions. Partially offsetting this spending growth is a reduction of $2.7 million for inmate education and training services that are realigned to the Maryland labor budget. The fiscal '26 allowance contains $4.1 million in general funds for body-worn cameras for correctional officers. The pilot program rolled out in February at the Patuxent Institution, followed by 4 additional facilities in March. The equipment included in the fiscal '25 pilot has been provided by the vendor as a sort of free trial at no cost to the state. Through the vendor, DPSCS has access to an automatic cloud-based system to process, organize, and store footage. DPSCS should discuss the terms of the pilot program and the plan to expand the program in fiscal '26. Due to the state's fiscal outlook, DLS recommends deleting the $4.1 million in general funds for the new body-worn camera program in fiscal '26. Turning to personnel on page 15, the allowance contains 1,279.8 regular positions, which is a net increase of 105.8, mainly due to transfers. 119.8 positions are transferred into the division from other agency areas, while 2 positions are abolished and 12 are transferred out. The new positions will support administrative functions as well as the Intelligence and Investigative Division and ITCD. The budgeted turnover rate decreases from 11.54% in fiscal '25 to 10.13% in fiscal '26, despite the actual vacancy rate being 14.29% as of December 31st, 2024. Language in the fiscal '25 budget bill restricted funds pending the submission of a strategy to eliminate the use of mandatory overtime. The report was not submitted in time for inclusion in the DPSCS overview analysis, so DLS recommends adding budget bill language to restrict $250,000 pending the submission of the report in fiscal '26. Similarly, DPSCS has not submitted the second of 4 quarterly hiring and attrition reports requested in the 2024 JCR. Thus, DLS recommends adding budget bill language to restrict $250,000 pending the submission of this report in fiscal '26. There are 2 issues discussed in today's analysis. The first issue highlights 2 major information technology projects that are behind schedule. The first project behind schedule is the Computerized Criminal History Project, or CCH, which will replace outdated technology with a state-of-the-art criminal history database and web interface. CCH was first solicited as an on-premises solution, meaning it was intended to be installed and operated on physical servers. However, during the initial procurement process, DPSCS amended the solicitation to a cloud-based solution, causing vendors to drop out of the project. The sole remaining vendor was awarded the contract, but before it could be approved, the department withdrew the contract and chose to restart the process so that vendor participation could increase. The second solicitation was advertised in July 2022, and DPSCS reported that it received 1 response by the due date, causing the agency to push back the expected contract approval further. Ultimately, DPSCS decided to cancel the process in June 2024. Because of the multiple reissuances and cancellations, the project's $2.3 million federal grant expired, forcing DPSCS to supplement costs with general funds. Now, nearly 4 years after the initial award and withdrawal of the contract, the project remains in its beginning stages. The agency reported that it has decided to pursue an in-house solution under the guidance of the Project Management Office and do it. The assessment phase is now expected to conclude by the end of the first quarter of fiscal '26, but the delays have led to a reduction in planned funding. The allowance includes only $50,000 budgeted in do it for oversight. DPSCS should explain its current approach to the CCH project, the extent to which do it is involved, and the reasons for the multiple cancellations and reissuances of the request for proposal. The second project behind schedule is the Electronic Patient Health Record Replacement, or EPHR. Since calendar 2005, the department has relied on its legacy system to track and document critical medical information. The current system has inefficiencies and issues with connecting to external information systems. A contract to replace the EPHR system was previously approved in October 2020, but the vendor failed to meet its contractual obligations, prompting DPSCS to issue a notice of default and terminate the contract in May 2022. The termination of the contract means that the agency paid the vendor $4 million in license costs that are no longer of use. DPSCS has since obtained BPW approval to extend the contract with its legacy vendor to ensure business continuity and adherence to the health record provisions in the devolving work consent decree. This 2-year contract extension was approved for $2.7 million. DPSCS is now considering utilizing an interagency cooperative purchasing agreement to move the project forward. This acquisition process is expected to conclude in May 2025, but the project is not estimated to be fully implemented until July 2028. The updated completion date is a concern because the Duval v. Moore consent decree is set to expire in June 2026, 2 years before the estimated completion date. Failure to progress this project could open DPSCS up to litigation, and the extension with the legacy vendor raises concerns about the continued use of an outdated system that may not meet the federal guidelines for standards of care. DPSCS should provide an update on the progress of the EPHR project and discuss Duval v. Moore compliance in relation to the services provided by the legacy contractor. Both projects are pressing needs. The ability to quickly access patient and criminal history information would cut down on the amount of employee time spent searching through records and ease the process for current and former inmates looking to access their information. DLS recommends restricting $500,000 pending the submission of a status report and updated schedule for both projects, describing the agency's procurement strategy for completing the CCH and EPHR projects, as well as evidence that the agency has procured a program manager to carry out the CCH project. The second issue in this analysis discusses violations of the Public Information Act. The Maryland Public Information Act grants the public a broad right of access to public record while protecting legitimate governmental interests and the privacy rights of individual citizens. The PIA Compliance Board rules on whether an agency has unlawfully denied inspection of a public record or failed to respond to a request within the established time limit. At this time last year, a total of 6 complaints had been made against DPSCS for improper denial of records and failure to respond, making it the most complained against state agency. As of the writing of this analysis, there have been 6 more complaints filed against DPSCS. The PIA Compliance Board determined DPSCS was in violation of PIA 4 times for failure to respond to requests, while 2 complaints still await decisions. Compliance Board decisions from fiscal 23 to 25 to date are compiled in Exhibit 7 on pages 20 and 21. The board found that DPSCS, quote unquote, clearly violated the PIA on multiple occasions and awarded fee waivers to complainants. The board found that DPSCS failed to respond to the public in a timely manner, but also that they failed to respond to the board itself and the PIA ombudsman on multiple occasions. While DPSCS is no longer the most complained against agency, it remains a concern that the Compliance Board continues to find DPSCS in violation of PIA, and that members of the public must file complaints to receive responses to their information requests. DPSDS should provide information to the committees on efforts to increase transparency, train records custodians to correctly identify PIA exemptions, and avoid complaints being brought to the Compliance Board. DLS recommends adopting committee narrative requesting a report on DPSDS's plan to ensure PIA compliance. Finally, turning to the recommended action section on pages 23 through 29, DLS is recommending restricting $500,000 pending a report describing how DPSDS has incorporated feedback from the Office of Legislative Audits regarding its medical and mental health contracts. I discussed this issue in the overview analysis, but the recommendation appears under administration and offices. And that concludes my presentation. Thank you, and I can take any questions now.
Thank you, Ms. Barber. Colleagues, questions? Delegate McComas.
Just a brief question. Do you know how many public information requests are made within a year for the Department of Parole and Probation?
I do not have that number on me. I might defer that to the agency. They might be able to respond to that. Otherwise, I'll get back to you with that.
Okay, thank you. Thank you, Mr. Chair.
Delegate Ivey, Vice Chair of the Committee.
Thank you, Mr. Chairman, and I appreciate the analysis. Really, the question is just, do you have like a number of requests that have been made that haven't been responded to in totality?
I don't have the total number. I would say that requests that have not been responded to are frequently escalated to the PIA Compliance Board, so I would say at least 6, but I don't have the full number.
Okay, thank you.
Colleagues, any further questions for Ms. Barber? Seeing none, Secretary Scruggs, you and your team can approach.
Good afternoon, Chair Lewis, Vice Chair Ivey, members of the committee. Thank you for having us again today. For the record, my name is Carolyn Scruggs. I am the Secretary of the Maryland Department of Public Safety and Correctional Services. With me today are Mr. Joseph Sadal. He is the Deputy Secretary of Administration, and Ms. Angelina Garino. She is the Assistant Secretary for Policy and Grants and Data Analysis. As always, we appreciate the collaboration with DLS and Ms. Barber's hard work on this analysis. I'd also again like to thank our DBM analyst that is here with us today, Ms. Christina Hore-Tuyon, for her advice and guidance during the submission process. The analysis contains 5 issues for the department's response and 9 recommended actions. DLS has requested the department comment on the reason for the increase in contraband levels and the steps being taken to reduce weapon contraband within the facilities. We are constantly fighting against new forms of contraband on a daily basis. Contraband can enter our facilities through external sources, such as smuggled in during visitation, sent through the mail, throwing contraband over the fence, or through the use of drones. It is also manufactured within the institutions in the form of incarcerated individual-made weapons. The most common types of contraband are Suboxone, synthetic drugs, tobacco, electronics, and weapons made by incarcerated individuals. We use a wide array of methods to intercept contraband to keep facilities safe. These include X-ray machines and scanners, physical searches and pat-downs, and our K-9 units. Metal detectors are strategically placed in areas where there is heavy traffic in all of our facilities. Our contraband interdiction team, also known as CIT, is deployed to conduct intelligence-based searches across our facilities. Our facilities maintenance department also plays a critical role in helping to determine the origin of in-house manufactured weapons and works to eliminate access to such materials. Weapon contraband recovery has increased due to a greater emphasis on conducting frequent and routine unannounced searches. The intelligence unit is responsible for gathering within the facility to identify any threats to the security of the facility, the staff, and the individuals that we house. The information gathered is used in efforts to interrupt planned assaults, intercept contraband from being introduced into the facility, and disrupt or eliminate assaults driven by retaliation between groups. The results of this proactive process have proven to be effective in recovering and intercepting contraband, as well as interrupting assaults. Most of these searches are conducted in conjunction with the K-9 and Special Operations Unit. Each academy class now also spends time assisting the CIT team on planned searches to instill the correct search methodology from the onset of their career with DPSCS. DLS has also requested the department to discuss the terms of the body-worn camera pilot program and the plan to expand the program in fiscal year 2026. The DOC body-worn camera pilot program involves 100 cameras and associated digital and physical infrastructure deployed across 5 designated facilities at no cost to the state. They have already been deployed in Patuxent and ECI. We have rollouts further at MCIW, BC BIC, and NBIC in Cumberland. The pilot will run for approximately 90 days, but will continue until the department has determined the operational viability of the effective agency-wide rollout of the body-worn camera program. These cameras have been assigned to employees in high-traffic areas. Body-worn cameras serve as a deterrent to inappropriate behavior, both for the officer and the incarcerated individual. To offer a few examples of success in other states, the Florida Department of Corrections has seen a 42% reduction in staff assaults. In New York, there has been a 52% reduction in PREA cases. In Lexington County, South Carolina, a 69% reduction in correctional officer injuries has been observed. The introduction of body-worn cameras is an important step in increasing accountability and transparency to the public and to oversight entities, and the digital infrastructure provides a secure platform for the managing of evidentiary disclosure. Correctional systems that employ body-worn cameras have also seen a decrease in litigation due to the introduction of video evidence that can now add proper context to the incidents. DLS has also requested the department comment on its current approach to the computerized criminal history project, to the extent to which DO-IT is involved, and the reasons for multiple cancellations and reissuance of the request. The project is progressing as planned with its updated strategy to prepare for future cloud migration. After the initial solicitation was canceled, the agency received approval from DO-IT to work with IBM and Amazon Web Services to conduct an in-depth analysis and clarification of the CCH code base. This aligns with the FY26 IT project request schedule, with the goal of completing the analysis of the legacy code base by the end of FY25. Once the refactoring phase is finished, the agency will release a new solicitation for replatforming the CCH application. DLS has requested the department provide an update on the progress of the EPHR process and discuss Duval versus Moore compliance in relation to the services provided by the legacy contractor. The department remains focused on securing a new implementation vendor. In order to expedite the vendor selection process and meet the major information technology development project requirements, the department is actively pursuing alternative procurement methods to expedite the selection of a vendor experienced in correctional health care records. Procurement efforts are expected to conclude by the end of FY25, in line with the FY26 information technology project requests. DPSCS continues to collaborate with its legacy vendor under an approved contract extension to ensure uninterrupted support, licensing, and enhancements while maintaining compliance with our Duval mandates. DLS has requested the department provide information to the committee on efforts to increase transparency, train record custodians to correctly identify PIA exemptions, and avoid complaints being brought to the PIA Compliance Board. The Office of Constituent Services, or OCS, continues to make great strides to ensure transparency, timely, and compliant responses to PIA requests, which has led to a sharp decrease in complaints brought before the PIA-CB. All GPSCS PIA requests are now funneled through OCS and a centralized tracking system, which was launched January of 2024. As of today, OCS has received and responded to all outstanding PIA requests and remains up to date with processing new PIA requests within the 30-day requirement frame. Staff members have received training, and new SOPs have been created with checks and balances in place to guarantee timely responses to all requesters. A 2.5-hour PIA training was given by the MPIA Ombudsman and the Office of the Attorney General for the department, which was recorded and shared with staff along with additional PIA resources. OCS conducted its first annual refresher training last month, facilitated by the Office of the Attorney General, and will continue to provide training refreshers to both staff and PIA liaisons on an annual basis. DPSCS is committed to enhancing transparency and timeliness in responding to our PIA Act requests. DLS recommended 9 actions, and we concur with 8 of those. We strongly disagree with the $4.1 million reduction in general funds for body-worn cameras. What I will say to you is about body-worn cameras, as you consider that and consider allowing us to maintain that funding, is that through this pilot program, we are already seeing positive feedback from our staff. We also were able to see that our staff had done exactly what they were supposed to do, because we were able to rerun the camera, and we saw the confrontational avoidance that they tried. We saw that they actually, both the nurse and the officer, the numerous attempts to have the incarcerated individual stop his negative behavior before we had to then progressively go into how we're trained to secure that individual. So it is already being received. It can definitely help us mitigate costs related to settlements that we are currently going through, some $2.7 million that we've already seen in settlements from this agency because of the absence of footage to support that our staff were doing exactly what they were trained to do. And it was not as dictated by that incarcerated individual. Again, we are happy to answer any questions that you have.
Thank you, colleagues. Delegate McComas.
Madam Secretary, I just have a quick question. I recall as when we were dealing with what happened to the gentleman that passed away before session, well, I guess in May or whatever. It seemed to me, the impression I got from my colleagues was that they really demanded that there be body-worn cameras. Was that your impression?
So the body-worn camera project that I speak of is in the Division of Corrections right now. The body-worn cameras that you're speaking of based on the Martinez case is for the Division of Parole and Probation. So they're two separate.
But they still do a very important facet.
Absolutely.
So can you maybe explain that?
Absolutely. So both internally and externally, what it allows us to do is ensure the safety and security of our staff. That's the first and foremost. And so what I want everybody to understand, that this is not, because some people think it's a gotcha, that we're looking at the staff to get them, but it is actually to protect them. So on the DOC side, is to protect that they have actually worked in a line with what they have been trained to do to de-escalate any incidents that are going on, and that the aggressive behavior was on the behalf of the incarcerated individual. We're missing that aspect right now, causing us to have a lot of settlements. Our hopes, because you know we have to have, it has to be statutorily approved in order for us to have it on the DPP side. So our hopes in doing that is it then gives our DPP agents another sense of safety, a feeling of safety as they have that, and that we're able to review and also use some of those as training tools for them as we begin to look at how we put them back out in the community. So theirs would be more used very similar to law enforcement as in the community as opposed to our DOC that are used behind the walls.
But I think the bottom line, though, is that it protects both the inmates and it protects the state workers, whether they be in or outside of a complex. And I think what it also does is I suspect you get a lot of inmate complaints that require legal action and you're sued, and this basically is going to settle the case that you're not going to have to,
Yes,
have
ma'am.
Mr. Crump come and sue the state of Maryland for millions and millions of dollars.
Yes, have we had the access to those body-worn cameras in the past? Many of these cases that are now coming up before the Board of Public Work for settlement, I suspect that we would have either negotiated the other way or been able to go directly to trial with evidence to prove otherwise.
Okay. Thank you, Mr. Chair.
I guess those are some isn't that so questions. Colleagues, any further questions for Madam Secretary? We'll start with the Vice Chair, and then I'll move over to Delegate Schindler.
Thank you, Mr. Chairman, and thank you, Secretary Scruggs and team, for the work that you've been doing, for the update, and for really focusing on transparency being a focal point. And it sounds like you've been training staff and walking them through the importance of responding to PIAs, so on and so forth. And so I guess my question is there anything that we need to do to make sure that when you come back next year, DLS is on the same page with you about PIA responses, or is everything great now?
So I will tell you that we have made major strides with PIA. When I first took this position, we had 605 backlog PIAs. Today, we have none. And last year, we processed 435 of them. Of the 6 that Ms. Barber speaks of, those 6 that went to the board, they're actually appeals. We responded to them, but now the requesters have appealed our request to their request to the board because they did not like our responses. So we did answer those requests, but they have that right to appeal and the board make a decision as to whether or not we relay more information. We also started that unit over again, because one of the things that I found was that unfortunately some of the people in that unit were not fit to be there. So we found them other opportunities throughout the department, and we hired fresh new individuals that were interested in working in that and interested with working with our constituents and understanding the timeliness and how critical this mission was. We now have 9 individuals, a supervisor and a manager that oversees that unit, that comes under my deputy chief of staff. And we're doing very well there. We work very well in partnership with the Ombudsman as well as the Office of the Attorney General, who graciously came in and trained each and every one of them. They've all been there for a year now. They got the refresher training, and we're up to date. So next year's report should tell you that we're up to date and there are no problems.
Wonderful. Thank you. I appreciate it, and thank you, Mr. Chairman.
No problem. Delegate Schindler?
Thank you, Mr. Chair, and thank you, Madam Secretary. My question surrounds the CCH project. I was wondering if you could provide a little bit more information. So in the report, it mentions that after a couple of stop and starts on that project and a loss of, looks like some federal grants of over $2 million, that now it's being assessed to be handled in-house. But I know, and you had just mentioned you're having AWS and someone else take a look at that, the feasibility for it. Can you talk a little bit more about that? Because it seems like we've got some conflicting information on that project.
Sure. I think when we're talking about in-house, we mean maintaining ownership of the system itself, right? One of the things that we found during the previous procurements were there's kind of an emerging technology related to CCH, the computerized criminal history, regarding the provision of SaaS solutions, where, as I'm sure y'all are aware, means that we're paying some sort of a licensing fee over and over and over again. So after the previous procurement, what we looked at was is this something we could do in-house? And given the criticality of a computerized criminal history system and the changes that frequently occur related to the requirements within it, was there a financially feasible method an efficient method to actually maintain the ownership and make the improvements and take this shift from the mainframe system to a cloud environment and be able to in-house provide any necessary changes going forward that would be necessary for the system?
Colleagues, any further questions? All right, I have a few, which I'm sure is of no surprise. First, I want to start off by saying I'm in deep agreement with you on the body-worn camera program and its uses. I think when we talked about this last year, we anticipated that it not only would help address some of the litigation that comes, but frankly, could be an opportunity to increase both for inmate and staff safety, and ultimately help with quality control for training, such that there is less gray on what is expected. And then when you see those instances, you can lift up your staff and be like, hey, this is a model of what we are talking about, so they feel appreciated. And I'm glad that's going the way that we intended. Some of the questions I have starts with some of the position transfers. So, we've been talking for a while about the vacancies and some of the difficulty that a lot of frontline staff has in particularly mandated overtime. And I just want to know, I think it was 119 positions or something to that effect of those transfers. And I just want to know, were any of these, some of those frontline, positions, and will it have any effect on those overtime numbers? Are we pulling folks that otherwise would help us address those overtime numbers and address the burnout that we're hearing about?
Thank you for that question. So one of the things that I saw when I came in office is that we had correctional officers working as administrative support in positions where we actually could have had a civilian body. So one of the reasons for realigning all of that was to take that correctional from that administrative support and put them back in the field, in the office, in the facility where they belong, on a post. So yes, as you continue to see us do that, it is going to help us and aid us in decreasing our overtime, because many of our facilities had become used to a correctional officer working as a warden's admin support, a correctional officer working as our fleet manager. So positions that we looked at, what are the positions that a civilian can hold within those facilities, so that it doesn't become a collateral position for that correctional officer who now is taken away from the facility need, but we can get that correctional officer back 24/7 in a correctional environment.
I'm really glad to hear that because, I think a lot of staff, as I've talked to some of your staff who are on the front line, and people appreciate the extra money up to a point, right? And then they burn out and they leave, and that exacerbates some of the challenges. So I'm glad to hear that. One of the things we heard in analysis was how I think for one of the programs, there was a program manager helping them move things forward. I guess I was going to ask, as relates to the CCH project, and there's been some back and forth, is there a program manager for that who's going to be focused on helping to move that forward? I know you said that we're bringing things in-house, but do we have someone who's ultimately responsible for the project moving forward?
Yeah, I believe that's what we're working with Department of Information Technology on, is to ensure that with a project of this kind of a scale, we don't have the sort of lag time of not having a dedicated individual to ensure that milestones are being met for whatever sort of outside vendor and internal processes need to occur in order to progress to the next step within the project.
Yeah, I just, for accountability, it is great. It covers y'all, it covers them, and we would love to be able to support you all and making sure there's a point person there that we can follow up with. I have to ask also on the recidivism data for 3 years, if you could speak a little bit more on that. As we know, we've done a lot of great work on bringing folks who didn't necessarily need to stay in jail really long home. But even with the population we currently have, something like 90% of people are eventually coming home, and we want to make sure that we are setting them up for success So if you could speak a little bit to that report, that would be very helpful.
Certainly. Thank you so much for that question, Delegate Lewis. As the analysis noted, we have seen in the interim a decrease in the single-year recidivism, but I would, as always, recommend caution. It is so important with this particular longitudinal outcome to allow time for the data to mature in order to get to the most accurate estimation of what is really driving these trends. Though the full report is not yet available, we have, of course, done internal analysis to get that data available. And for the past year, that is the 2021 three-year cohort, is the first one that started to see some of the cohort come out of that COVID closure period. And I speak not to our operations, but to the community. So as all other states saw, there was a significant fall off in recidivism during that COVID period because people stayed home. Behavior fundamentally changed within the community. Other states, as they've opened back up, have seen a slight return to a pre-COVID, I would say a normal in recidivism. We have seen similar, 32.15% over a 3-year period, but we are still seeing the persistent changes in that first and second year post-release, which is when we tend to see the highest challenge for individuals to re-enter society successfully and remain not justice involved. But we will, I think, over the next few years, start to see what the state could expect to be a very accurate foundational estimation of what we would expect those return to prison trends to be, especially for future planning, beginning with the FY 23 and 24 cohorts.
That's really great to hear. When do you think we can expect the report?
Before the end of session, ideally within the next few weeks. We just had some technical setbacks.
Okay. Thank you. My last question is on the contraband, and frankly, it's, while these folks are in the care of the state, we have to protect them. I know you all are laser focused on that. Please communicate to us what in support, help you guys need as you address this weapons contraband issues. It seems, even in my time here, and this is my 9th session, how contraband enters has evolved fairly rapidly. So I know it's kind of like whack-a-mole, and I acknowledge that. We've dealt with drones, we dealt with things in mail, we've dealt with some personnel changes that had to be addressed. If you could just speak a little bit more to address the weapons
Thank you
contraband.
very much for that question. So I think one of the things that we want to reiterate is that we have become more aggressive in our searches. And in doing that, we expected our contraband numbers, our fines to go up. That's what we want to happen. So where searches were not being conducted every month, I am requiring now that searches be conducted. I am requiring that our CIT unit be out in the field more frequently and are convened more frequently. We're having unannounced searches that not even the warden knows that you're showing up at their facility 3 a.m. in the morning and we're going to search. So we increased our unit, our CIT unit, our investigative unit, so that we could cut down on that. Again, as you stated, our incarcerated population is very creative when they come to contraband. Contraband typically involves something that has been made within the facility, whether it is fermented juices that they have changed into what they term jump juice, that's contraband, or whether it is a homemade weapon that they have taken and say they've broken a chair, and they've taken that and they shave it on the floor until it gets sharp. They'll wrap their sheet around it and they keep it in their housing unit. We also be mindful that I have a lot of aging facilities, and my aging facilities, we're trying to patchwork a lot of things because, being honest, it has not been a lot of money put in the corrections for maintenance over the years. And so they will take a window fixture, or they could take a piece of, say, this chandelier, let's use that for example. And once they've broken that off, they again use the concrete on the floor to shave it, and they're making their homemade weapons. So we know that, and we know that some of our areas, we've had to constantly maintain maintenance in those areas, and those are high traffic areas or either housing areas where our incarcerated population lives. So we're more frequently searching there. And as we continue to more frequently search, we're going to do more fines. One of the other creative things that I know Ms. Barber put in her report is that we are seeing mail that's come in, and mail has been sprayed. They're actually spraying with Raid now. You can purchase it on on Amazon, you can purchase it. However, and our dogs are not detecting things like raid. So again, they are being very creative in the use of everything that they have at their disposal. We had a recent incident yesterday. The incarcerated individual used their finger clip so that you clip your nails with, and they sharpened it. And we had an incident that we found it because they had sharpened it and made it into a tool. So they are becoming very creative. It is because we have removed their ability to get the normal weapons that you would see come in. So now they have to think of, what are the other ways that I can protect myself in here? Because again, remember, they're facing the same population behind the walls that they faced on the street. So they may have enemies that they have not shared with us that we don't know about, and they're trying to, or it could be also harm to our staff, which we definitely don't want to happen.
So I have one final one, and I really appreciate your response and all the efforts on behalf of you and your staff to keep folks safe, address the contraband, deploy the body-worn cameras, all of this. So last year, we spoke a little bit about the use of tablets for educational purposes, but also, frankly, for control of the environment. I just want to know if you all could share anything as it relates to that. Is that program? I know some folks are using it for education, some for those with privileges to communicate home. If you could just talk about that a little bit.
Yes, everyone has a tablet. Everyone receives a tablet upon intake into our facilities. It is up to you whether you lose that privilege to have a tablet. But we have also been able to update our tablets. We've updated our tablets with an entire series application of educational opportunities where they can sit right in their housing units and earn certificate-based options for them. We are working very closely with our post-secondary partners, Bowie and UB and Goucher, to make sure that the institution and use of tablets is part of our educational opportunities. Some of our wardens have even been very creative with the use of the tablets. For example, if an incarcerated individual gets an infraction for something, that does not necessarily mean that they need to be sanctioned for some type of cell restriction. The warden is then directing them to a program, a behavior management program, say, on that tablet, and says, once you complete that program and come back and talk to me, I'll restore your visits. So we're using those tablets in a lot of various means in order to mitigate the negative climate of the population. And it continues to do, those tablets continue to do well.
Thank you. I mean, it's their window into the world, too, so I know many of the inmates cherish that opportunity, and conditioning access to that can also alter behavior that hopefully should help keep the place safer. Colleagues, any further questions? Seeing none, thank you so much.
Thank you, sir.
All right, we're going to keep moving along. Let's see what that's. Next, we have Office of the State Prosecutor. So, Mr. Polikoff, you can begin your analysis, and then we'll bring Mr. Howard up to speak.
Thank you very much. Excuse me. Thank you very much, Mr. Chair. Jacob Polikoff for the Department of Legislative Services with the budget analysis for the Office of the State Prosecutor. Just as a refresher, the Office of the State Prosecutor is an independent agency within the executive branch charged with investigating and, where warranted, prosecuting criminal offenses affecting the honesty and integrity of governmental officials, institutions, and the electoral process. The state prosecutor can investigate on their own initiative or at the request of multiple parties, including the governor, the attorney general, the General Assembly, the State Ethics Commission, or state's attorney. Certain criminal offenses, including election law and public ethics law violations, state bribery law violations, misconduct in any office by public officials or employees, and extortion, perjury, or obstruction of justice related to any of the aforementioned. In addition, the state prosecutor is empowered to investigate and prosecute any offense that takes place in more than one county within the state or in more than one state, including Maryland. The fiscal 26 budget, as we see on page 1, increases by $1.3 million, or 37.6%, to $4.7 million. Reimbursable funds total about $1.2 million, or 25.7% of the fiscal 2026 allowance, due to the Governor's Office of Crime Prevention and Policy providing funding for a collaborative effort with the U.S. Attorney for the District of Maryland to investigate and prosecute violent acts and firearm violations, along with criminal gangs throughout the state. On page 2, we have a section regarding fiscal 2024. The budget bill includes a deficiency appropriation of just over $145,000 to fund shortfalls in OSP's fiscal 24 budget. The largest share of the shortfall is in contractual services, and that was $143,238. OSP should comment on the circumstances that led to these shortfalls and if they expect similar issues at the end of fiscal 2025. Additionally, OSP should comment on the status of resolving the issue with the information on these shortfalls being reported to the comptroller and then to DLS as was supposed to be done at closeout. The next section regards fiscal 2025. In addition to the proposed deficiency appropriation covering the prior year shortfall, OSP also receives 2 proposed deficiency appropriations to support fiscal 2025 costs. These have a net impact of increasing the general fund appropriation by $193,403. They include funding for rent increases for the agency's new office space and increases in garage parking expenses at the new facility, along with funding for the agency's moving costs. On page 3, we have Exhibit 1, which shows, again, OSP's total allowance of $4.7 million. Salaries for regular and contractual personnel account for 89% of the allowance, including 18 regular positions and 13.5 contractual full-time equivalents, or FTEs. The majority of the funding for contractual FTEs is for special assistant United States attorneys and staff, and funded by a grant from GOCPP that I mentioned. As we see in Exhibit 2 on page 4, the increase of $1.3 million to the fiscal 2025 working appropriation after accounting for deficiency appropriations. The largest change is the creation of 13 new contractual positions funded with those reimbursable funds from GOCPP. The funds are used to pay contractual FTEs working with the U.S. Attorney for Maryland in investigating and prosecuting violent acts, firearm violations, and criminal acts throughout the state. A budget amendment for fiscal 2025 that is not yet reflected in the working appropriation adds $1.2 million in reimbursable funds for the same purpose. After accounting for that budget amendment, the fiscal 2026 allowance for OSP increases by $78,264 compared to the fiscal 25 working appropriation. On page 5, we have our personnel data. And we see that there's one new regular position in the fiscal 2026 allowance that's actually a contractual conversion for one paralegal position. Accordingly, there's an elimination of one contractual FTE. Additionally, OSP has eliminated another half of a contractual FTE position, which it is determined is no longer needed. And as mentioned, the allowance includes 13 new contractual FTEs, which are designated to support the agency's collaboration with the U.S. Attorney for the District of Maryland. They include 8 special assistant U.S. attorneys, 3 paralegals, 1 program manager, and an analyst. And although they appear as new in the fiscal 2026 allowance, the budget amendment, which funds them in fiscal 2025, has not yet been fully processed and does not appear here yet. On page 6, we have our first key observation, which discusses the Official Misconduct and Special Victims Unit, which just completed its first year of operations. This unit was created in fiscal 2024 and is devoted to investigating official misconduct along with cases involving special victims. The existence of this unit allows the office to place a more direct focus on cases involving matters of official misconduct and cases involving special victims, and to separate this work from the other areas of the office. The agency began reporting statistics from this unit this year as part of their annual Managing for Results submission. And as we see in Exhibit 3 in the middle of page 6, the unit received 58 complaints in its first year and opened 8 investigations. Now, OSP expects that the number of complaints and investigations will grow slightly over the next 2 years as awareness of the unit and its purpose grows. OSP has previously stated and continues to state that this unit is focused not only on prosecuting cases, but also on increasing awareness of these types of cases and educating agencies about what constitutes official misconduct or what constitutes a case involving a special victim. Their goal in increasing awareness is to start investigations at the time the complaint is received by an agency, rather than having the case be identified as one of official misconduct or involving a special victim only when they become involved, which can be much later in the investigatory process. OSP is actively working with inspectors general and other state agencies and other authorities to provide this education and increase awareness. In fiscal 2024, OSP made contact with 48 victims and witnesses as part of its investigatory process after receiving complaints. Charges were brought in one case in fiscal 2024, and OSP should report on the conviction rate for cases brought by this unit, independent of other case types in future years, and the number of cases closed each year. On page 7, we discuss criminal conduct complaints and investigations, which increased, and closed cases, which have decreased, according to the data. OSP receives complaints and referrals regarding misconduct in office, bribery, extortion, perjury, obstruction of justice, and other offenses. These complaints and referrals may be received from private individuals or groups, or from public employees, elected officials, or agencies. As shown in Exhibit 4, which is at the bottom of page 7, in fiscal 2024, OSP received 1,022 complaints. Subsequently, 138 investigations were opened. OSP previously stated that growth in complaints was expected to taper off in fiscal 2024. However, the number of complaints increased by more than 300, with 29 more investigations open than the prior year. OSP subsequently closed 153 cases in fiscal 2024, which is a decrease of 110 closures from the prior year. Therefore, the agency should discuss the reason for the decline in cases closed and their efforts to increase the case closure rate. With that, Mr. Chair, you'll find on page 8, the recommendation from DLS is to concur with the governor's allowance, and I'm happy to take any questions. Thank you.
Thank you, Jacob. Colleagues, any questions for DLS? Seeing none, Mr. Howard, you can come up and begin your testimony when you're ready.
Again, thank you, Mr. Chairman and members of the Public Safety Administration Subcommittee. My name is Charlton Howard, and I am the State Prosecutor for the state of Maryland. I appreciate, once again, the opportunity to talk to you about the important work of our office. I am joined here today by our Deputy State Prosecutor, Sarah David, our Director of Administration, Ruth Sweeney, and our Senior Assistant State Prosecutor for Election Law and Election Integrity, Brittany Dunklow. We would like to thank our tireless analyst, Jacob Polagoff, for his outstanding work, not only on this report, for his consistent engagement with our agency throughout the year. Thank you very much, Jacob. We appreciate it. As the statistics have shown, our offices continue to take on important corruption and election laws throughout the state. As 3 examples, we prosecute cases during the past year. We prosecuted a Prince George's County councilman for 6-figure campaign theft. We prosecuted the Anne Arundel County Register of Wills for theft of funds meant to pay the taxes on an estate within her office, and a Cecil County Sheriff for misconduct in office involving a special victim. The first issue, our wide-ranging cases and expensive state role also led us to move offices last year. For those that have been with the legislature a number of years, you've seen our number of, we're a small but elite unit, I like to think, but we have increased in size over the past year, and we have not moved offices in over 25 years, and it got to a point where I was facing OSHA complaints if I crammed too many more people into single offices. So we did move offices, and that, to jump ahead just a minute, accounted for the vast amount of the additional funding we needed because there were not hidden, but there's different costs in moving, not only regular moving costs, but that we brought all of our furniture with us. We did have to buy some more, and those kind of things that come into play in moving the office. But hopefully we won't have to encounter that again for a number of years, so I don't anticipate those deficiencies for a number of years to come. The Office of State Prosecutor has jurisdiction over specific crimes related to political corruption, official misconduct, and election law, as Jacob explained. When we came here last year, we announced our new unit devoted to working misconduct and sexual assault investigations, essentially official misconduct involving special victims. We are pleased to announce that this unit had its first trial this last year. A contested trial was successful in convicting a Talbot County police officer who was having sex with teenage girls while on duty. This is one example of why we founded the unit. It's because we found these type of cases that everyone thinks official misconduct, white-collar crime. But you think official misconduct involving victims, it requires entirely different skill sets in many cases, and victim rights advocacy and other things to ensure the case is prosecuted in line with official protocols, but that person is held accountable for the misconduct in their office. The second issue we were asked to address is how do we maintain conviction rates in this unit. This answer is that this unit is designed to ensure that victims are able to report their assaults and find justice. One reason for our outreach is to ensure that agencies are aware when they get these kind of complaints to bring us in immediately. We want to avoid re-traumatizing the victims. We want to make sure that appropriate services are provided and that evidence is preserved so if someone needs to be held accountable, they can. But most importantly, that victim of state action, whether inadvertent or intentional misconduct, is taken care of. During this year, last year, we made contact with 48 victims and witnesses, as Jacob mentioned, and as the existence of our unit has become known, we expect that will rise. We're already starting to get calls from a lot of our colleagues in other offices and a lot of our colleagues in the IG and administrative investigative community who are not particularly well postured to deal with these kind of cases, and now they find someone who can be brought in to provide advice or to take over that particular investigation if it's within our jurisdiction. A majority of these cases will not see the courtroom, but working with victims to find a resolution and ensure future protection for those individuals. We're also working to provide statewide training and spread information about the existence of the unit and how it could serve as a resource for various departments and administrative spaces throughout the state. Our new office space will assist in that. We do have a training room involved in that space, and we've already hosted joint training with State Board of Elections and some other agencies, and we anticipate that continuing much further over the next year. Key area for that training, as I mentioned, State Board of Elections is an election law. It's my pleasure today to introduce Brittany Dunklow, who is our most recent addition to the office and is our new Senior Assistant State Prosecutor for Election Law. Brittany has an incredibly impressive background. This will be actually her first prosecutorial role, as she previously served as a public defender in Baltimore City and extensive work with complex civil litigation. As informing our unit and looking at the skills available within our agency, we think adding those civil litigation skills, adding those skills provided by both public defense as well as prosecution will ensure the compliance that is our goal in election law. We always want to see compliance. We're not here to try to deter people from participating in the electoral process. If they participate fraudulently, we want to hold them accountable, but we want to ensure that there's compliance with our law, as is fiscal transparency accounting generally, to ensure that there is widespread transparency in the process for people and for the voting electorate of our state. Brittany is not only helping us continue to build on election law program, build on compliance, but she's also working on ensuring our election laws can address modern technologies, such as how artificial intelligence and deepfake technology can impact our elections. As if it wasn't difficult enough sometimes to ensure fair and clean elections with the older systems, now we have modern technology continues to evolve and continues to be utilized. So we're trying to stay on top of that, ladies and gentlemen, to preserve that transparency, again, for our process. While our resources are limited, we work hard for our important mission. We credit the work of Jacob, particularly in his analysis today, in pointing out a flaw in our report. He mentioned that our case closure rate had gone down in 2024. So when he pointed that out in a report and we saw it graphically, we looked at that, and actually that was our error. In the past, we've computed case closure rates by adding the number of investigations closed and the number of cases that did not result in an investigation closed. Cases that we actually engage in investigative work on, we look at a complaint, determine, invest some resources, but determine it just isn't within our jurisdiction or isn't sufficiently colorable to initiate a full-fledged investigation. When you add those numbers together, as we have in the past, we are actually up at 570 cases closed, which is well above what you would expect in the normal ratio, given the number of complaints that we have raised. So I believe that our numbers are a fair indication now of how we our work. And we are working with DBM to correct our MFR with that particular number. But it's, I'm very proud of that. I just would like to add that as Jacob mentioned, we did not expect our volume to increase as much as it is. sometimes you become a victim of your own success. And as more people learn about the agency, learn about what we do, we get a large number of complaints. Many of the complaints that we do receive are not within our jurisdiction, which is fairly limited, even for a criminal prosecution agency. But I'm very proud of the fact that we take our role as state employees and gold standard customer service seriously. So a large number of those complaints we receive that are not within our jurisdiction, we refer to agencies that do have jurisdiction. And so over 50% of the complaints that we receive that we do not actually open an investigation on are referred to another state or federal agency that can assist the person who's making the complaint to our office. And a number of those complaints come from our traditional sources, but as I mentioned last year's testimony, we made the mistake of putting a complaint portal on our website, and that has managed to get a lot of information coming in. I speak, of course, flippantly about that because it is very important for people that are not familiar with the system to know how to get in touch with us. And that complaint portal has been critical for us in getting the number of complaints that we need to cast the net wide enough to ensure we identify the issues that are out there that we can work on. We appreciate the governor's allowance in our budget and concur with that allowance. Thank you so much for your attention and your support of our office. We provided also written testimony to address in more detail the issues that Jacob provided, and we stand ready to address any questions at this time.
Thank you for your testimony. Sorry for calling 500 times and issuing complaints. No, I'm joking.
We took each one seriously, Mr. Chair.
Questions, colleagues? Delegate McComas.
No, I think all my colleagues have received an email from someone numerous times, actually twice a day, probably the exact same thing. Are you guys working on that situation? And I'd be glad, or if you're not, who should I send the email to? Because it involves, without disclosing the mess, I don't want to, cause any more problem. But I just want to make sure that you're aware of it and whether, or you can send it on to where it should go. And I'm being very obtuse.
Are you referring to a complaint that came through email?
This has been an ongoing issue, and we've all received the emails. Some of you may not read them, but it deals. Well, I don't want. I'll talk.
If it is one, I would encourage you to follow with them offline if that's okay.
Yeah.
Delegate McComas, you can send it to my email. I'll follow up with your office after this hearing.
Okay. All right. If you give me your, do you have a card?
Yes, but I can also just follow up with your office.
Okay,
no
great.
Okay, great.
Thank you.
Yeah, I'd love to be able to respond directly, but we get, unfortunately, a lot of emails on consistent issues, and I'm not sure, I can't narrow it down to which.
We'll talk offline.
Yeah.
No worries. Vice Chair Ivey.
Thank you so much for the work that you all do, and it's critically important, just as a state, that we have your office providing this transparency, so on and so forth. My question, I saw, I think it was $1.1 million in reimbursable funds. I assume that those are federal funds or grants?
No, what that is, Mr. Vice Chair, is in this past year, there's a program that has been working with the U.S. Attorney's Office in the state of Maryland to directly, and using state funds, to directly address the violent crime that has really ravaged certain areas of our state.
Sure.
And for those that are familiar with the world of criminal law and criminal prosecution, there are a lot of tools in the federal system that you can use, sometimes more tools than we have in the state system to address those issues, particularly with firearms and violent crimes. So there is a program to fund state-funded positions detailed as special assistant U.S. attorneys or paralegals to work with the U.S. Attorney's Office in Maryland, but to work exclusively on violent crime affecting the state of Maryland. And so that's the program that we took over. It was previously administered by the Attorney General's office, but we've taken over that program. So it was 13 PINs that are within that. They're contractual PINs, and they work within either Greenbelt or the home office of the U.S. Attorney in Baltimore to address those specific violent crime issues. And we administer it's administering the program, essentially, for the state in that regard.
Thank you. I appreciate it.
Colleagues, any further questions? Thank you all very much. Thank you for the work you do.
Thank you very much. Thank you all.
Thank you.
All right, next, we're going to have the Office of the Public Defender. Mr. Polikoff will begin. I have to step out for something, so our Vice Chair will be presiding over this. Please don't take personal offense to that, Ms. Public Defender. But after Jacob finishes his analysis, then you and your team can approach. Okay, thank you.
I think you just didn't want to hear my voice for a second agency in a row, Mr. Chair. You apologize to the public defender, not me. Okay. Thank you very much, Mr. Chair.
She's an Eagles fan.
Oh, I'm still taking it about the Eagles. All righty. On a more serious note, the Office of the Public Defender provides counsel and related services to indigent persons through 12 district operations, 4 divisions, and 2 specialized units. Indigent has a specific definition as defined in Code of Maryland regulations. It means any person taken into custody or charged with a serious crime who, under oath or affirmation, subscribes and states in writing that he is financially unable, without undue hardship, to provide for the full payment of an attorney and all other necessary expenses of legal representation. Legal representation is provided in criminal trials, bail reviews, appeals, juvenile cases, post-conviction proceedings, parole and probation revocations, and involuntary commitments to mental institutions. As we see on page 1, the fiscal 2026 budget increases by $9.3 million, or 5.9%, to $166.2 million total. General funds increased by $9.4 million, or 6.1%, in the fiscal 2026 allowance compared to the prior year. That increase is largely attributable to the creation of 51 new positions, along with various other expenses, which have increased to align with fiscal 2024 actual expenses. The fiscal 2026 budget includes 1 proposed deficiency appropriation in fiscal 2025 to fund fiscal 2024 shortfalls in the amount of $2.2 million in general funds. If we exclude that proposed deficiency appropriation, general funds increased between fiscal 25 and 26 by approximately $11.5 million, or 7.5%. For fiscal 2025, we're going to combine a discussion of cost containment and the implementation of legislative priorities. Section 21 of last year's budget bill added $500,000 in general funds to the agency to increase salaries for existing positions. The salary increases were intended to promote the agency's employee retention rates in order to combat the longstanding issues with a higher than budgeted number of vacancies. In July of 2024, the Board of Public Works approved 1 cost containment action impacting the agency, and it reduced the agency's appropriation by approximately $1.1 million in general funds appropriated for salary increases for existing staff as a retention initiative, including the $500,000 in general funds, which had been added to the appropriation for that purpose. At fiscal 2024 closeout, OPD reported having insufficient appropriation to cover $2.2 million in expenditures. A proposed deficiency appropriation provides the general fund appropriation in fiscal 2025 to cover those fiscal 2024 expenditures. Of the appropriation, just about $1.3 million is to provide additional funding for panel attorneys and medical consultants for legal consultations and testimony. The remaining $932,973 is added to provide additional funding for printing contracts, transcription services, and other contracted services. We have Exhibit 1 on page 3, which shows that the allowance totals $166.2 million, with 81%, or $135.3 million, funding the District Operations Program. District Operations is the largest program containing most of the agency's assistant public defenders, or APDs, and is responsible for the majority of the representation provided by the agency. Exhibit 2 on page 4 shows the fiscal 2026 allowances increase of $9.3 million compared to the fiscal 25 working appropriation. The fiscal 26 allowance includes $5.2 million in funding related to salary and fringe benefit costs for new positions and to provide additional office furniture for new employees, along with trainings and new laptops. The fiscal 26 allowance also includes costs associated with 51 new positions, including 16 assistant public defenders, 5 intake specialists, and new paralegals, social workers, and other administrative positions. We'll note that in fiscal '26, the funding for panel attorneys is potentially insufficient. Panel attorneys are paid by the agency to provide representation for clients when OPD's attorneys are unable to do so due to scheduling conflicts or conflicts of interest. OPD has required deficiency appropriations in 2 consecutive years to cover shortfalls for panel attorney fees in the most recently closed fiscal year. As we see in Exhibit 3 on page 6, fiscal 2023 actual costs for panel attorneys were reported as $11.4 million, and later an additional $1.8 million was required to fully fund costs for panel attorneys. In fiscal 2024, OPD reported actual expenses of $12.1 million for panel attorneys, and the deficiency appropriation for the same purpose increases the total cost to $13.4 million. Despite these additional expenditures, the fiscal 2026 allowance slightly decreases the amount budgeted for panel attorneys. However, both the fiscal 2025 and 2026 budgeted amounts are notably lower than the recent expenditures. Given the agency's recent history of requiring additional funding for this purpose, the fiscal 25 working appropriation and fiscal 26 allowance may require additional funding for panel attorneys. The total cost grew by 2% between fiscal 23 and 24, and if these costs continue to increase at the same rate each year, the fiscal 2025 working appropriation may be underfunded by $1.1 million, and the fiscal 2026 allowance may require an additional $2.9 million. OPD should discuss the reason for the lower funding in fiscal 2025 and 2026 for this purpose compared to the recent actual experience and how any shortfalls in the spending would be covered. On page 7, we have the personnel data, which shows that the fiscal 2026 allowance includes new positions for all 4 programs within OPD, including 16 assistant public defenders, 11 secretaries, 9 office clerks, 5 intake specialists, 2 social workers, and 2 paralegals added for the district operations program. The fiscal 2026 allowance also includes 5.5 fewer contractual positions than the fiscal 2025 working appropriation. OPD has elected to eliminate these positions due to a lack of current need, and those positions included 1 assistant public defender, a peer recovery specialist, 2.5 social worker positions, 1 part-time office secretary position, and 1 part-time family services caseworker. OPD has had consistently high vacancy rates for a number of years. Of the 80.5 current vacancies, 31 were newly created with the fiscal 2025 appropriation, including 12 assistant public defender positions and 9 secretaries. As we see in Exhibit 4 on page 8, the number of vacancies is broken down by the length of time for which the vacancies existed. And while the number of vacancies at OPD has decreased over the past 12 months, the agency's difficulty with filling newly created positions serves to increase the severity of the vacancy problem. The 51 new positions added in the allowance include positions for which there are already a high number of vacancies, including APDs, social workers, paralegals, and administrative staff, as we see in Exhibit 5 on page 9. OPD's vacancy issues contribute to the caseloads issue, which we'll discuss in a moment. When OPD's attorneys depart, they cite a variety of reasons, including higher rates of pay or lower caseloads, which are available at other state agencies, federal agencies, or the private sector. Historically, OPD has filled higher level positions by promoting from within. This method of filling a vacancy by creating a new lower level vacancy does allow for OPD to hire a greater number of applicants for entry level positions. However, the agency has previously stated that they often fail to recruit graduating law students due to competition from other employers, which results in continued issues with vacancies, particularly for APD positions. Data provided by the agency demonstrates the need for additional attorneys, paralegals, and social workers. However, their struggles to fill vacancies make it prudent to reduce the number of new positions in other job categories. Therefore, the Department of Legislative Services is recommending reducing $1,697,000 in general funds and deleting 12 new office secretary positions, 9 new office clerk positions, 2 new administrative positions, and 2 new information technology related positions. On page 10, we have a discussion of the agency-wide caseload, which has remained steady. In fact, it's remained fairly static over the most recent 4 fiscal years, excluding cases which were handled by panel attorneys in each year between fiscal 21 and fiscal 2024. The agency handled between 122,351 to 127,660 total cases each year. As we see in Exhibit 6, which is in the middle of page 10, in fiscal 2024, 69.4% of these cases were district court misdemeanors. This represents a statistically normal year. for OPD, as district court misdemeanors have historically been the largest practice area each year. The decreased number of cases over the last 4 years as compared to prior years has allowed OPD to decrease its usage of panel attorneys, which reduces the total amount of fees that the state pays to private attorneys to cover the cases OPD cannot handle. In calendar 2019, OPD needed to panel a total of 54,417 cases to private attorneys. In fiscal 2024, that number had decreased to just 12,193. OPD should continue to work to balance the workloads for its regular and contractual APDs to ensure that the use of panel attorneys is kept as low as possible in order to stay within the funds budgeted in the allowance for those attorneys. Attorney caseloads are still a focus and continue to exceed current caseloads. OPD began utilizing nationally recognized caseload standards in fiscal 2024. These standards were created by a group consisting of the American Bar Association, RAND Corporation, and the National Center for State Courts to calculate standard workloads for attorneys. OPD has since begun a process to alter these new standards to better reflect Maryland's specific circumstances, which in turn will allow them to calculate appropriate caseloads for public defenders in the state. OPD has solicited proposals for a contractor to assist with the process of altering the national standards, and the contract was awarded to RAND Corporation, which was part of the group that created the original standards, and approved by the Board of Public Works in November of 2024. Until the adjusted standards are approved by OPD and adopted for use in the agency's annual MFR submission, the agency continues to use the national standards and anticipates that the adjusted standards will be completed, by February 2026. OPD is currently understaffed in terms of attorneys, paralegals, and social workers, according to their report on attorney hiring, separation, and caseloads, which was submitted in December of 2024. The report stated that in fiscal 2024, OPD lost 45 attorneys to resignation, 9 to retirement, and 13 to transfers, while 1 attorney was terminated. These 68 attorneys lost were replaced by 104 hired attorneys, making fiscal 2024 the first year since fiscal 2020 where more attorneys were hired than separated from OPD. The data contained in the fiscal 26 MFR submission indicates that with the current total number of budgeted APD positions, including vacancies, the agency is understaffed for its current workload by approximately 1,025 attorneys, as we see in Exhibit 7 on page 12. The area with the greatest calculated need is circuit court felony matters, where OPD estimates a need for 792 additional attorneys in order for each attorney to have an appropriate caseload. This calculated need represents an increase from the estimate provided for fiscal 2025, when the agency estimated that 677 additional attorneys were needed for circuit court felony matters. The data indicates that OPD is understaffed in every practice area except for mental health matters, and the gap between the number of attorneys OPD has versus what is needed according to standards represents a significant issue. Current workloads are unsustainable for many attorneys, which can lead to low employee morale along with high turnover and extensive continued use of panel attorneys, along with other consequences. OPD should continue to focus on enhancing its recruitment and retention methods, as filling vacant positions would decrease caseloads for all attorneys and has the potential to aid in retention efforts even absent additional positions. OPD should comment on which case types the new APD positions created in the allowance will be assigned to, and if these assignments will result in standard caseloads for any of the case types where attorneys are currently beyond standard caseloads. During the process of adjusting the national caseload standards to better reflect Maryland, OPD should work to determine if procedures can be adjusted to reduce the number of additional attorneys needed for every attorney to have a caseload that meets standards. Procedures to be examined could include how administrative staff and paralegals contribute to casework and whether different cases can be weighted differently in workload calculations based on complexity. On page 13, we have 2 recommended actions. The first is to reduce $94,198 in general funds to increase the turnover expectancy for contractual positions to 10%. The second is the action previously mentioned to reduce just under $1.7 million in general funds and delete a total of 25 new positions to delete a total of 25 new positions. With that, I thank you very much, Mr. Chair, and I'm happy to take any questions.
Thank you, Mr. Polico, for the wonderful analysis here. Colleagues, any questions for DLS? Seeing none, We have Public Defender Dartigue here and team, if they could please join us. And whenever you're ready, you can take it away.
Good afternoon, Mr. Chair, members of committee. I am Natasha Dartigue, Public Defender. Seated to my right is Deputy Public Defender Keith Lottridge, and to my left, Chief Financial Officer Thaddeus Hubbard. I thank you for the opportunity this afternoon to discuss FY26 budget for the Office of the Public Defender and to respond to DLS's FY26 budget analysis. I do want to first thank and recognize DLS budget analyst Jacob Palikov for his thorough analysis, and I do take an extra moment to highlight his high degree of professionalism and the impressive way that he is quick to respond even on hearing days to questions, and we had numerous questions over the last 2 weeks. So a heartfelt thank you to you, Mr. Palikov. So I begin by emphasizing that in partnership with DBM, OPD Senior Administrative Team has successfully advocated for additional PINs in the governor's allowance for FY26. This number represents not only a partial phase buildup for meeting our staffing needs. So I'm thankful to DBM for their work in assisting OPD navigate these challenging times. My request today is that you concur with the governor's allowance and approve the FY26 budget as presented by the governor through DBM and essentially make no cuts. This is not an unreasonable request. The severity of the needs of OPD were heavily considered in the DBM analysis as reflected by the governor's allowance. I thank Governor Moore for his continually recognizing that OPD serves a critical function in the state, and it is a function that no other agency does or can perform. We at OPD stand side by side with Maryland's each day. Think of the pre-petition young mother facing financial crisis in Prince George's County, the 30-year-old man battling mental health in Harford County, or the young woman who is in need of community-based services in Anne Arundel County. The needs of OPD directly reflect the needs of the individuals that we serve. We provide constitutionally mandated representation and services throughout Maryland. OPD's value of investment also reaches beyond the courtroom. We are the subject matter experts who collaborate with local, state, and national partners on addressing systemic problems. We bridge and reinforce connections between OPD clients and appropriate community-based services. However, the reality is that OPD is in crisis. The staff positions reflected in the FY26 budget are urgently needed. And when I speak of urgent, I would like to provide you with a visual. Many of you are familiar, and if you're not, I want you to think of the game of Jenga. And essentially, it is a game where every piece is stacked, and every move is a gamble. So you think about the loss of a secretary is essentially a removal of a piece, or the loss of an IT staff, or low wages is essentially a loss in the game, or a high workload. So as we continue to take away from an agency that is already under-resourced, what you are left with is unstable, risky, and on the verge of collapse. And here we're talking about what impacts lives, not only the lives of the clients that we serve, but we talk what is equally important, the lives of the employees who are public servants, and public servants who are doing extremely difficult work. So now I want you to think about the sturdy Legos. Colorful, built to last. They represent our comparably well-resourced prosecutors' offices, where each block you see is the reinforcement of funding and support. And even there, if you were to remove a block, it's still left sturdy and the foundation remains strong. I also want you to take notice in that the blocks are multicolored. The vibrant colors essentially reflect the differences in salaries, as well as the fact that, unlike the Office of the Public Defender, the state's attorney's offices throughout the state receive funding from their local governments. The Jengas that represent OPD is a solid color because our main source of funding comes from the state. We do not receive any monies from the individual counties or Baltimore City, although we have 52 offices that span across the state in all 23 counties and Baltimore City. So notwithstanding the visual, I do want to emphasize that the day-to-day operations at the Office of the Public Defender is in no way a game. Not the recruitment efforts, not the retention challenges, not the repercussions that we face by being under-resourced. It is not a game. OPD, however, continues to utilize multifaceted approaches to filling our existing vacancies. As of January 31st, 2025, there were 41.5 attorney vacancies. This is a 6.7 attorney vacancy rate. Our core staff vacancy rate as of the same date was 10.03, making it a combined vacancy rate of 8%. When I sat here last year before you, the attorney vacancy rate was 13.75%, and the core staff rate was 8.7%. The overall vacancy this time last year was 11.88%. Despite improvements, we continue to tackle the problem in that people leave to do very similar public interest work in other places for more money and a lighter workload. The excessive workloads do in fact contribute greatly to attorney and core staff turnover. It is extremely problematic for OPD to lose seasoned attorneys because those are the individuals who handle the most serious felony cases in the circuit court. The new positions do in fact represent a strategic investment in the people who currently work at OPD. Our core staff are essential workers, and I'm talking not only the paralegals and the social workers, but also the secretaries, the intake staff, and the IT. Their efficiency and effectiveness are essentially crucial to our operations. And I give you the example. The proposed cuts include IT. In fiscal year 25, our IT budget was $1.58 million. When you think about the fiscal year 25, the judiciary had a IT budget of $75.8 million. And in comparison to OPD, they had 173 IT positions. OPD has 20 IT positions. These positions in the judiciary and OPD cover essentially the administrative operations of data center, our automated systems, and support of infrastructure. So similar functions, but when you think about OPD compared to the judiciary, we are woefully under-resourced. In fiscal year 25, the judiciary had approximately 4,165 employees. OPD had 1,050 employees. We had about a quarter of the employees that the judiciary had, but when you compare the budgets, we essentially had less than 3% of the IT budget that the judiciary had for similar services. This is unacceptable. When you talk about retention, this dramatically affects retention. Our OPD attorneys and staff carry excessively high workloads. And when you think about how technology has increased over time, that has also impacted the work to be more intensive. Think about body cam. It also requires a greater level of legal expertise. Think about cell phone triangulation. It also requires more technical administrative support, electronic filing, and discovery. Excessive workloads reverberate through issues in recruitment, retention, compensation, and morale. We are currently looking to criminal defense tools to redefine and imagine these essential tasks, especially when we talk about evidence analysis and trial preparation. However, understaffing directly impacts morale, job satisfaction, and the quality of representation. The national workload standards that Analyst Polakov spoke of that were released in 2023 did provide a clear picture of all practice areas, did not provide a full picture of all practice areas of the Office of the Public Defender. However, it did give us great insight. The total number of lawyers alone would need to rise to 920. We currently have 606 authorized positions. As of today, OPD has 575 attorneys. Additional resources are needed to meet our day-to-day challenges. And I cannot allow this opportunity to pass without also emphasizing that we must better compensate all our employees in order to recruit, retain, and provide superior legal representation as we are required to do so, but most importantly, because our clients deserve it. As a leader of the Maryland Office of the Public Defender, I lead an incredible team of talented, dedicated, and resilient public servants. OPD's value to Maryland warrants significant investment beyond what I am requesting today. And it is with the full understanding of our current fiscal climate that I do make this request. So I am asking that you adopt the FY26 budget as presented by the governor's allowance through DBM. I urge that no cuts are made. OPD defends individuals. Individuals are the core of families. Families build communities, communities that we talk about from the mountains to the shores and everywhere in between. The value on investment in OPD is ensuring justice, fairness, and dignity for all people of Maryland. Thank you for your time and attention. I welcome questions.
For your words here and your response to the analysis. And quite frankly, the work that you do and the organization that you're leading, we know that it's an incredibly difficult thing to do, hiring people and recruiting them, retaining them nonetheless. You've made a lot of headway, and I just want to commend you for that, and also for the visuals today as well. We love the additional touch there. Colleagues, are there any questions? Delegate McComas.
I just want to say you're probably the most efficient, best-run legal office in the state of Maryland. You work with what you work. You don't have the best clients in the world that are most articulate or understand the game, but you are the best, and you do the best you can for people, which is a wonderful thing. You're great public servants. With that, I have a real quick question. Do your attorneys that go into court, let's say maybe circuit court, the more serious crimes, do they have access to laptops so that they can use during the court proceeding and, kind of track things, or are they kind of hampered by that? Does all your attorneys have them, or just the circuit court group, or?
So all our attorneys have laptops. The challenges are that the laptops don't have service, so they have to rely on the Wi-Fi at the particular location, which varies from location to location.
So in other words, let's say something comes up in a criminal trial and the state brings something up, and so they want to be able to look up what they're talking about and maybe get some of the latest research on it. Would they have access in that courtroom to be able to do that, to search the web?
If they have access to the Wi-Fi,
to be able to kind of counter what the state's saying.
So it's actually a pretty technical question, but so let me give you an example. In circuit court, all circuit courts are basically run by the county.
Right.
And the state's attorneys are also part of the county government. They're generally all running on the same network or all have the same access. Our attorneys come in on a state system, and our state system, we have a lot different security, a lot different, let's say, call it handshaking, and we're not always given the same access in every courthouse. And a lot of courthouses we are, but not all of them. Quite often we don't have, even if we have access, we don't have quite the full access the state attorney might have at this time. We certainly quite often don't have the same speed, and there are occasions when we simply don't have the access. Every now and then, our attorneys will literally pull out their phone to do something in court because the laptop they may have may not have the connectivity we'd like it to have.
So basically, it depends on if your attorney is that savvy with the phone to get the information that he might be looking for then.
Well, it depends. So it depends on the access to be able to connect in the courthouse. It depends what they are looking for. So if you are doing a case search and you're seeking to look at your laptop, that is one thing. If you are seeking to connect so that you can view a discovery or something of that nature, then it depends as to what is the software that it's downloaded on. And throughout the state, we have varying state's attorney's office, but the challenge is also the number of law enforcement jurisdictions that we have, and there is not one universal software. So as a statewide entity, one of the challenges that we have is essentially keeping up in terms of the various technology that exists throughout the state, the various software, and the various services.
So I guess just to capitalize or to recap what you're saying, basically you all don't have the ability to maybe make quick turnarounds like the county state's attorney's office does because you don't have, your state, you get your money from the state, but all these other prosecutors that are the county prosecutors, they get their money from their county, and some of them are probably get more money from, it just depends on the county.
So yeah, so especially when you talk about technology, and that's why I gave an example in terms of the judiciary's budget, because that is an entity that we interact with on a daily basis. So that impacts our ability to do our jobs, the ease with which we're able to do it, and our ability to access information, how quickly we're able to access, and how we're able to share that information.
Okay. Thank you, Mr. Chair.
I'm just going to follow up. Essentially, yes, you're correct. Quite often, the local jurisdictions can get federal grants for, there's a lot of federal grants for law enforcement, including state's attorneys, and the local jurisdictions will get those, and they'll put that on top of their county money, and then they also get funds from the state itself. So they might have three funding sources where we have this august body, which I am grateful for, but more would help.
If I may, basically, you come in with a revolver and they come in with a machine gun as far as the computers. Is that fair to say? A good analogy or not?
That would not be the analogy we would use. But yes.
Good. Thank you.
No, thank you, Delegate McComas. And if we can be of help reaching out to some of these courthouses, asking for you all to be granted more access, please let us know what we can do. Delegate Schindler.
Thank you, Mr. Chair. Thank you guys very much. So I've been hearing a lot about technology. It seems like technology is a struggle for you guys. But a question I have for you is certainly there are new positions that are being requested. There's a lot of unfilled positions, but when you made comparisons about the IT staffing between the judiciary and yourselves, kind of the comparison, how does the total staffing kind of compare? Do you have any idea what that looks like?
So in terms of IT staffing, so for fiscal year '25, the judiciary had 173 positions to help facilitate their 4,100 employees. Okay. OPD has 20 positions to help facilitate our 1,050 employees. So when you think about the ratio, and again, we are a statewide entity, those 20 individuals are assisting in services from your day-to-day difficulty and challenges in accessing your computer to to put up your discovery, to issues that you may have in presenting in court. These 20 people have to essentially provide services throughout the state of Maryland. And again, that's less than one person for each office. We have 52 offices across the state.
Thank you. That helps paint a picture. I appreciate it.
Thank you, Delegate, for the question. Madam Public Defender, thank you for the work that you're doing. Again, let us know what we can do to assist and to be helpful.
Approve the budget.
Thank you for your candor. We do have one more witness here. Steve Musselman from AFSCME Local 423.
Excuse me, Mr. Chair. Actually, I think there are 4 witnesses.
Okay.
Thank you.
I see a few others. Okay, they have maryland.gov email addresses. So is Robin Nolan here? Okay, and Lance Wines?
Present.
You can come on forward. Anisha Littell?
Here.
Wonderful. Come right on up. And then we'll go with Mr. Musselman. But we'll have you wait. Thank you. I do want to make sure everyone's aware that for this panel, everyone will have 2 minutes each. So whoever would like to start, please take it away.
I'll go. Hello, my name's Robin Nolan. I am a resident of Harford County, and I have been the office manager for the Harford County Office of the Public Defender since 1996, and I've been employed with the Public Defender's Office for 35 years, 10 months, and 11 days. As you know, the office employs attorneys to represent our clients in criminal matters. Our attorneys cannot be effective in court without the support team behind the scenes, the core staff. We have office clerks, intake specialists, secretaries, paralegals, peer recovery specialists, social workers, and office managers who all play a pivotal role in assisting the attorneys in their representation of our clients. I recently went to court to watch a closing argument for a murder case of ours, and I looked around the courtroom when I got there, and there was not one person there for our client, not one family member, not one friend for a murder trial. After I sat down, the client turned to his attorney and asked who I was, and they replied, "She is here for you." He turned to me, he nodded his head, and he smiled. The core staff is supporting the attorneys in their job. They get beat up by the judges, they get beat up by the state, they even sometimes get beat up by our clients. And our role is to give them an environment of safety and less stress. The core staff takes everything we can off the attorney's plate so that they can focus on representing the client in court. Without us, the system breaks. We cannot go to court and represent the clients, but we are advocates for them in our own way. A reassuring phone conversation, an application filled out, securing a bed in a treatment facility, a legal issue well-researched, a subpoena typed. Without the core staff to handle these everyday office tasks, the attorney cannot walk into court for their part. Our caseloads are too high for the attorneys to give the clients all that they require. We are never at full staff on both sides of the coin, attorneys and core staff, but we stand together in our work. It is our calling, it is our mission. We are all public defenders representing our clients to the best of our abilities. Thank you.
For the work that you do and for being here today. Would you like to go next?
Yes, thank you. My name's Anisha Littell. I'm the Division Chief of the Post-Conviction Defenders Division of the Office of the Public Defender. We obviously do post-conviction work. For those of you who are not familiar with that process, we determine whether errors of a constitutional nature were made during the trial or the appeal, and our efforts can lead to a variety of forms of relief, but most of the time it leads to a reduction in years of sentences. Now, the work we do is critical for a variety of reasons that you've already know about, that you've heard about today, but it also saves the state of Maryland a lot of money. Just last year, the number of years that we reduced from people's sentences was 575 years. And in my estimation, that's about $23 million savings to the state of Maryland that the state will not have to pay out because those folks will not be incarcerated for that full sentence. Also, this number does not include all of the relief that we obtained for the lifer group who tend to be older folks that cost the state of Maryland even more money. But we desperately need help. Every incarcerated person or person on parole and probation is entitled to post-conviction relief, and they're entitled to counsel to get it. The private bar does very few of these types of cases, and so we really have the lion's share of all of the incarcerated and people on parole and probation in the state. And the crushing caseloads are impossible to manage. Our unit, when fully staffed, has about 26 attorneys for the entire state. And every single week, I have at least one, if not more, attorney in my office discussing their feelings of guilt and shame for their inability to handle their caseload. And our attorneys work nights, they work weekends, they pour their hearts and souls into these cases and our clients. The caseloads cause tremendous stress on our folks. And their feelings of inadequacy are not just about the attorney, being an attorney. It's about being husbands, wives, and parents, because they're losing in every aspect of their lives because they can't keep up with the work. And despite my best efforts to make it more manageable, it is simply a math game we cannot win. As a result, as you've heard today, we lose excellent attorneys every single year. Our division not only saves the state a lot of money, we reunite families, we help to stabilize communities, we put a lot of people back in the workforce, and we restore dignity. And we are asking you to support Maryland families by supporting OPD. Thank you.
Thank you. Mr. Wines?
Certainly, thank you. My name is Lance Gunnar Wines. I am an Assistant Public Defender Level 2 in Hagerstown, Washington County, and I have yet again been tasked with the impossible ask of setting aside my ego as a trial attorney and giving credit where credit is due. On any given day, I represent between 12 and 24 clients in a district court docket. Just this morning, I had 3 clients set for trials by jury in the Circuit Court for Washington County, but I made it here to speak on behalf of and for the people behind the scenes. Because before I can do my job, there are a lot of people that support me to get here. First, there's Julie, who's our intake specialist. She's the one who ensures that our clients are public defender eligible and gets all of our contact information to make sure that we can represent them moving forward. After Julie is Randy, who is our office secretary level 2. She creates the physical files, the manila envelopes, folders that we take into court. She's the one who puts together the paperwork so that I know who I'm working with because I have such a extensive caseload. After Julie and Randy, there's Casey, our office secretary, level 3. For me, she helps me to communicate with my clients. She helps me to file motions for requests for discovery on my behalf because our workload is so large. After Casey is Janelle, our administrative aide. Janelle does everything that I do and everything that all of our attorneys do, but about 100 times better and more efficiently. She is truly the cornerstone of our office. There's Teresa, our office secretary level 3. Teresa does everything that the ladies up front do for the district court team of 7 district court attorneys by herself for a team of 5 or 6 circuit court attorneys. She is, again, a pillar of our office. There's Gwen, who is a paralegal level 2. She files subpoenas. She makes sure that we have our background information to know who the witnesses are that we will cross-examine when we get to trial. And there's Cheryl, our office manager, and she puts together all of the physical resources that we need to run an office. And I cannot forget this time, Kim and Rashida are lovely social workers in Washington County. I will say that those people, those individuals are the ones that make my job special. And I'd just like to say, this is real quick, that our office is not a well-oiled machine. Our office is a nuclear reactor, safe and efficient, only because of the brilliant and dedicated minds that clock in every single day to make the magic happen. So thank you, and I just want to thank them as well.
Thank you, and I'm sure that they're all saying thank you from wherever they are watching right now. Mr. Musselman?
Mr. Ivey, members of the committee, my name is Stephen Musselman, and I've served as a public defender over 20 years. I'm here today as a proud member of the executive board of ASME Local 423 in Maryland Defenders Union. We represent more than 2/3 of the office, lawyers, social workers, and core staff, that you helped form a few years ago. Our voice joins with our boss's voice today that we are in crisis and don't cut anything. I go farther than don't cut anything. I would say add. Our membership, our members fill the role, as Lance just told you. I worked with him in Hagerstown. I'm in Frederick now. In the constitutional system, we're constitutionally mandated, but we have to ask for funding to meet the U.S. Constitution. In light of the role that we play, it's imperative that we be funded in a manner that affords our energy clients the legal representation they deserve, the Constitution requires, and their dignity requires. Budgets are moral documents. You all know that. They represent what our values are, what our society expects, and where we should allocate our public resources. Those Jenga blocks are coming out every day in our office. The cuts that you're being asked to make our core staff are going to cause that tower to fall over. What we ask for you is to send a message. Send a message that the indigent and the poor are important in this state, and they deserve not just competent representation, but nuclear representation, because that's what we do. That's what we do every day. I, too, was in court this morning. I was on the phone at 7 o'clock with a district court lawyer who's new. I was in a lockup at 8 o'clock talking to a gentleman from Perkins. From 9 to noon, I was with that client who was from Perkins. I then got in a car to drive down here as a representative of the union to tell you that we are in crisis. We are in crisis, and we ask you, don't cut. Ms. Tartine, what she told you, I'm going to play over and over again for everybody in our office. You cut, that Jenga tower comes down. It's going to come down slower if you don't add to her request. The studies that she's citing are glaring of what we're failing to do for the people in Maryland. The attorneys, the core staff, the social workers are fleeing my office. For county attorneys' offices, state's attorneys' offices, U.S. attorney's office, federal public defender. There's no way to compete. I'm 20 years. My peers are on our way out. We want to leave the office for Lance in a better position than we find it in. But it's hard to do when people are fleeing the office. They're fleeing the office because of caseloads, and they're fleeing the office because we can't compete with the salaries that people need for core staff, for social workers, and for lawyers. I know right now you're dealing with the cuts that are being made, not just what's being proposed in the governor's budget, but the cuts will be devastating. We appreciate what the governor's allowance of new positions are going to do. It's going to invest in our future. It's going to invest in bringing our caseloads down. For a few years in Hagerstown, I carried more than 90 cases at any given time. I couldn't serve the poor the way that I wanted to. I'd ask each one of you, with all due respect, if you had 1,000 bills you were asked to work on today. It can't be done. But constitutionally, we have to do it. And as our post-conviction unit chief said, yes, my family suffers. I want to have breakfast with my wife at 7 o'clock, but I can't. I couldn't. The constitutional duties that we're called upon to do, we want to meet. We want to meet them. By cutting $1.7 million from the budget and losing 12 core staff members, I can't imagine the impact in my office in Frederick or in Hagerstown. In Frederick alone, my secretary supports 7 lawyers. She should be supporting 2 or 3. She should be supporting 2 or 3. That cut will prevent her from getting someone to help her. We're asking you to do no harm. We're asking you to address the crisis. Thank you.
No, thank you. And I really appreciate the words from the 4 of you giving us a on-the-ground perspective. So your words don't go unheard. It's an incredibly difficult year that we're going through, and you see that in some of the analysis presented today. But again, I want to thank you for being here, for making the time, for driving down, and for serving the people who have been unserved so often. So seeing no other witnesses, that concludes the hearing of the Public Safety and Administration Committee today. Thank you so much for being here.
Thanks. When you decide to come.